The story begins on 22nd of May 2015. That is when Salim Juma Hakeem Kitendo, a wealthy Muslim man from Mombasa, sadly died. Now, Salim died intestate, which in legal terms it means he died without a will, which in Kenya is the legal equivalent of saying, niko na inheritance, we kuja na madem. Ladies and gentlemen, boys and girls, welcome back to another episode of Katiba na Chai. We are loving the responses we're getting from you. Please keep it here on Katiba and Chai. Now, if you followed the news at the end of June 2025, you would think that the Supreme Court woke up just one morning and said, let us test national unity today. Kadhi Courts are finished. Islamic inheritance law is dead. Ha, ha, ha. The Constitution has finally decided to pick a fight with religion. Ha, ha, ha. Yeah, none of that was true. None of that was true. But the reaction was real. And the reaction was loud. See, after the judgment that was delivered on 30th of June 2025, the response there was immediate. Not just tweets, not, hey Edgar, I don't like Supreme Court. Not just grumbling, but entire press conferences were held within days. From late June to early July, Muslim leaders were addressing the media directly.
Isitoshe, tunataka ofisi ya Chief Kadhi ipatiwe mamlaka ya kutosha, iwe ni ofisi ya kuheshimika. Maadamu sisi ni Waislamu, walipa ushuru katika hii nchi, lazima na sisi haki yetu ya kidini iwe ni yenye kuangaliwa na hii nchi.
Now, I need to make this clear. What you're hearing is not just confusion, it's fear. It was fear that the constitutional line had shifted. It was a fear that Kadhi Courts were being weakened. It was a fear that a promise made long ago was starting to erode. And to understand that fear, allow me to take you back. Not to 2025. No, let me take you back to 1963, before independence. So, the Kenyan coast at that time was not just a piece of geography. It was tied to the Zanzibari Sultanate. It was tied to Islam, and it was tied to trade and centuries of personal law. So, when the rest of mainland Kenya was negotiating independence in 1962 and 1963, most leaders on the coast raised a concern. Okay, if we join the Christian majority state, what happens to our personal law? Now, the answer, as happens in this country, was a deal. Kuja tuchape ka deal. Sheikh Nani, kuja tuchape ka deal. So, Kenya gets Mombasa in the coastline, but Muslims in the country retain their personal law for matters like marriage, matters like divorce, marriages like inheritance. And that deal is why Kadhi Courts exist, even to this day. So back then, they were entrenched at the Independence Constitution, and today they sit under Article 170 of the Constitution. And Article 24.4 of the same Constitution then allows religious law to apply to matters that like marriage, divorce, inheritance. Meaning, if you're under any of these matters and you're a Muslim and you choose to submit to it, it's perfectly legal. So when people, especially the Muslims, reacted strongly in July 2025, they were not inventing a fear. They were remembering a history. But here's the problem. History explains the reaction, but history does not answer the legal question. Here at Katiba na Chai, that's what we are here for. Because the Supreme Court was not deciding history. The Supreme Court was deciding one family dispute. The story begins on 22nd of May 2015. That is when Salim Juma Hakeem Kitendo, a wealthy Muslim man from Mombasa, sadly died. Now, Salim died intestate, which in legal terms it means he died without a will, which in Kenya is the legal equivalent of saying, niko na inheritance, we kuja na madem. Now, Salim was a wealthy man. He left land, he left houses, a whole business, and the small matter of 9 children and 3 wives. Okay, technically 3 women, but now the order here matters because first there was Fatuma Athman Abud Faraj. She's the appellant in this case. Fatuma was Salim's first wife, and she was married to him under Islamic law. Now, Salim and Fatuma had 4 children together, and they were all born within that marriage. So her status as a widow was never in dispute. Fatuma's her status was secure. Her children's rights to inherit was never in dispute. Yeah, alikuwa fiti. Her case was not about her children, no. It was about who else should be included and who should be excluded from the property. Now, second, Rose, also known as Rose Faith Mwawasi. This is the first respondent. Now, Salim began cohabiting with Rose before any Islamic marriage happened. And when they were cohabiting, they had 3 kids. Now, later, after the birth of those 3 kids, Salim and Rose, they celebrated an Islamic marriage. Her position was simple. My children are Salim's biological children. And they should not disappear just because when the marriage was happened, they had not yet been born. I mean, they had been born after the marriage had already happened. Now, third, as you can see, Salim was out and about. Marlene Coram Cornwall, the third respondent. Salim also cohabited with Marlene. Salim, bro. Now, they later purported to celebrate an Islamic marriage. Now, less than 6 months after that marriage, Marlene gave birth to a son. Now, the validity of Marlene and Salim's marriage was still in dispute. There were questions about the capacity of Salim during that purported marriage, right? But the paternity of the child was not disputed. In legal terms, Marlene was saying this, Sawa, okay. We may say the marriage is not correct, but biology does not care about paperwork. And finally, there was someone called Judith Malele Mwawasi. I know what you're thinking, no, Salim, nothing happened with Judith, okay? She's the second respondent, and she entered the succession cause in 2015 as a co-petitioner and an administrator. Administrator is who the court allows to be in charge of gawing the shambas and everything. So she was claiming a share of she was not claiming a share of the estate. She was saying, please, don't distribute this estate in a way that deletes some of the children. Okay? Now, as the case moved from the High Court up until it reached the Supreme Court in 2023, Fatuma was asking for some clear declarations. Fatuma was asking the court, I want you to declare that Islamic law exclusively governs the state. No other law, just Islamic law. And as a result, children born outside of a valid marriage cannot inherit under Islamic law. Declare that Article 27 on equality was limited by Article 24.4 on Islamic personal law, and that the Court of Appeal was wrong to harmonize Islamic law with constitutional equality and children's rights. So, the court decided on the 30th of June 2025. Now, I'll pause here. If Fatuma had had her way, some of Salim's children would not have inherited land, income, and security. Others would have gotten everything, but most would have been left out. Not because Salim wasn't their father, no, but because adults somewhere were disagreeing about the timing and the form of marriage. Now, this is where the Constitution steps in. The Constitution, its job is not to debate theology. You can do it in your churches, your synagogues, and your mosques. It's here to stop harm. So here's the legal timeline. Now, 25th March 2022, the High Court applies Islamic law, but recognizes the children born out of wedlock as dependents. So yeah, tutagawa according to Islamic law, but for the kids' part, lazima warithi. Now, on 10th November 2023, the Court of Appeal agreed with the High Court that all children should benefit and rejected exclusion based on marital status. Now, they went to the Supreme Court, and the Supreme Court issued a stay, saying, okay, until we decide this matter, no distribution is happening. But on the 30th of June 2025, the Supreme Court delivered its final judgment on the matter. And that judgment, my friend, drew a boundary, a firm one. It said that religious law applies only to the extent strictly necessary. Okay? This phrase matters. It means that Article 24.4 is not a blank check. The court said this, and listen carefully. Denying children born out of wedlock the same benefits accorded to children born within wedlock on the basis of alleged sins of their parents is unreasonable and unjustifiable. The Supreme Court said that this was not an attack of faith. It was a rejection of downward punishment. The court then relied on Article 53.2 of the Constitution, which talks about a child's best interest. the court said that a child's best interests are of paramount importance. So in every matter concerning the child, paramount. And paramount means first. That's the first thing we consider. So in 2015, when Salim died, in 2023, when the appeal was filed, and in 2025, when the judgment was delivered, the Constitution is basically saying this. You guys, adults, you can argue morality forever. You can be on WhatsApp, you can be on Twitter, you can be in real life. You can argue morality whenever you want to argue. However, those should not involve children as collateral. The Supreme Court dismissed the appeal and affirmed that all children may benefit, and sent the matter back to the High Court for distribution by a different judge. So basically, what we're saying is that Kadhi Courts still exist. Islamic personal law still applies, but not at the cost of children. So when you saw press conferences in early July 2025, you kind of understand where the reaction came from. It was not just about a ruling, not that they read the ruling and were like, whoa, no. It was about politics, it was about history, it was about identity. It was rooted in a fear of erosion. But the judgment itself was narrower. It did not weaken Islam. It limited one thing: the use of religious law to exclude children from inheritance after a parent's death. Salim died on the 22nd of May 2015. And for 10 years, this family lived inside the law. And on 30th of June 2025, the Constitution drew a line. Not a line against faith, but a line against harm. Ladies and gentlemen, that's been Katiba. Achai. My name is Tiger Shira. See you in the next one.